Excited Utterance, the Evidence and Proof Podcast, Episode 171, Alfred Yen, the Evidentiary Use and Misuse of Forensic Musicology in Copyright Litigation. Welcome to Excited Utterance. I'm your host, Ed Cheng from Vanderbilt Law School. Excited Utterance is your podcast for cutting-edge scholarship and developments in the world of evidence. We bring virtual workshops to you throughout the academic year. This week, our guest is Fred Yen. Fred is professor of law and Dean's Distinguished Scholar at Boston College Law School. He teaches and writes in copyright and intellectual property, as well as torts and sports law. Our podcast this week features Fred's article, The Evidentiary Use and Misuse of Forensic Musicology in Copyright Litigation. It was published last year in the UC Davis Law Review. In it, Fred comprehensively covers the issue of musicologists in copyright litigation. Trying to determine whether a hit song was copied from someone else is tricky business. Direct evidence of copying is usually not available, so we're left with inferring copying, but that requires knowledge of music theory and an understanding of how music is put together, something that normal people don't know a whole lot about. And then copyright law itself makes things even more confusing, because beyond copying, a plaintiff normally has to show improper appropriation, a sort of harm standard in copyright. And doctrinally, this particular aspect of the claim depends not on an expert's ear, but a layperson's. All of this means that musicology experts have not only the potential to be incredibly helpful in copyright cases, but also the potential to usurp the jury's role. My conversation with Fred takes a close look at musicologists, what they know and don't know, and what should be the proper limits of their testimony in court. Fred, delighted to have you on Excited Utterance. Welcome.
Thank you very much. I'm excited to be here.
Your piece is about musicologists and copyright litigation, which I have to say seems to constantly show up in the news these days. I think about Ed Sheeran and Marvin Gaye's heirs. I think that's the most famous recent edition of this saga. But apparently, I was just looking it up, Ed Sheeran also just settled the case with Faith Hill and Tim McGraw. So this happens all the time. I would venture to guess that most of our listeners don't know a whole lot about copyright. Certainly, I fall in that camp. So maybe you can set that stage for us. And maybe this is a bit of a dangerous question to ask a copyright scholar, but what's the underlying copyright doctrine in this space? What do we have to know about it?
Sure. Let me see if I can distill this down, recognizing that I spend several hours talking about this if I were teaching a copyright class. So first of all, let me recognize that we've all had this experience of listening to a song and going, it sounds like another song that I've heard in the past, right? And when we hear that, in our minds comes the question, I wonder if the second composer copied from the first composer. Now, that is part of what would make a valid copyright infringement claim. In order for a plaintiff to succeed in a copyright music infringement claim, the plaintiff has to prove two things. First, that the defendant copied from the plaintiff's work. And second, that the nature of the copying is so large that it becomes an improper appropriation from the plaintiff's work. And so I want to make sure that listeners have in their minds the difference between what does it mean to copy from somebody's work and how do we prove that? And what does it mean to go too far, for the two works to sound so much alike that the copying now becomes illegal? And the reason that I want to do that is because expert witness testimony in copyright is only supposed to be about the former. For the latter, courts pretty consistently say that's up to the jury. They can listen to the two songs and they'll tell us whether there's too much borrowing. So that's a quick nutshell. I'm sure that there will be other things that come up as we discuss.
Good. So just to clarify, so what we have here is you can copy some, but not too much. And the not too much is the second prong. So you have to have both the copying and then the too much part on the second part.
That's right. And if you think about this from a literary point of view, we could imagine an author borrowing a few words from a large novel, and we wouldn't have a problem with that. Academics do it all the time.
Okay, so then let's move to the expert piece of the paper. The piece is, of course, about musicologists. How have courts used musicologists to help resolve these cases?
All right. So if we return for a moment to the initial scenario I suggested, here's two pieces of music, parts of which bear resemblance to one another. Is this copyright infringement? A lot of the times we as lay people would say, I don't know, right? You hear two pieces of music that sound alike. Did somebody copy one from the other? Maybe, right?
Right.
And so the idea here is, well, all right, let's bring in some musical experts, musicologists, and maybe they can help us figure out whether copying occurred. So what this does is turn musicologists into the star witnesses in music copyright infringement litigation. If Marvin Gaye is suing, his heirs are suing Robin Thicke and Farrell, the musicologist becomes everything because lay people on the jury are speculating. They don't know. So that's what happened. And the challenge then becomes how do we use expert witnesses properly? Right now, according to doctrine, musicologists are supposed to help jurors decide whether there has been copying. And that's really what the paper's about. I think that courts give far more prominence than the field of musicology deserves.
Now that we've set the stage, what's the problem? So the paper is really about what musicology experts shouldn't be allowed to testify about. And it seems that they've been going outside the bounds of the doctrine. What are the things that musicologists are doing that we need to be careful about?
So we take it as a given in evidence law that expert witness testimony needs to be reliable, right? So that's Dalbert and Kumho, for example. And I think that there are lots of things that musicologists testify about for which there is no basis for reliability. And the biggest concern that I have is when an expert witness testifies, in my opinion, X copied from Y. I don't think the field of musicology offers any kind of standard analysis, any kind of testing, any kind of peer review. All that we get, in my belief, when a musicologist says, I think X copied from Y, is a personal assertion of the expert's belief. It may be an educated or even informed assertion, but it's not reliable within the meaning of the rules of evidence.
So there are a couple of other things that experts testified to that you object to as well. So one is when experts stray into the improper appropriation piece. And I think the other thing you objected to, and I think some of this is seen in the podcast I did with Rebecca Tushnet, when experts talk about the rarity of different features. Tell us a little bit more about those.
Yes, so let's start with the rarity aspect. When somebody says, look, I think that X copied from Y because the common identifiable features of the two works are rare, the expert is making some kind of quasi-probabilistic assertion about the relative likelihood of copying versus coincidence. But for that calculation to be valid, as Professor Tushnet points out in her paper with Professor Bucafusco, you need a lot of evidence, or a lot of information that musicologists don't have. So for example, it matters whether there are 10 composers composing in a genre or 50 million composers composing in a genre, because by the law of large numbers, if 50 million composers are doing it, the chance of a coincidental similarity eventually arising is much greater. I don't think musicologists really have that information. So that's one thing. The second thing that you mentioned is the difference between testimony about copying and testimony about improper appropriation. Now, the hallmark of an improper appropriation determination would be for the jury to listen to the works and say, you know, they sound so much alike that we think the copying is wrongful. Notice here the underlying perception of the jury is about, do the two works sound too much alike? Now, when an expert witness testifies about copying, and he wants to say the similarities between the two are so great that I think that copying has occurred, the expert witness will effectively say, to me, the two works sound too much alike. Oh, no, wait a minute. What is the expert affecting the jury's perception of now? Copying or improper appropriation? And I don't think courts police that line well at all.
So on this last point, though, a lot of that trouble has to do with the doctrine and how the language of the doctrine almost encourages the expert to stray between the two factors and to get into this second factor, which by all accounts in the doctrine is reserved to the jury. It's almost like a determination of negligence, right? It's a layperson determination, but the language is confusing.
Yes, it's a truism among copyright professors that the law of copyright infringement is, at the very least, inartfully stated. It's true that many formulations of doctrine use the phrase substantial similarity in very confusing and inconsistent ways. So courts will say, we allow an inference of copying when two works are substantially similar to one another. And then in the same breath, they will say, we will allow a finding of improper appropriation when two works are substantially similar to one another. Well, okay, so when the expert comes in and testifies, are the two works substantially similar to one another? The court may be thinking, ah, yes, the expert is addressing the question of copying, which is entirely proper. But how do we know that the jury doesn't hear the words substantially similar and think, he's telling us the works sound too much alike and there's improper appropriation? And of course, that assumes that the jury understands the difference between the two.
So let me go back to the first point you raised, which was the concern about Daubert and whether these musicologists actually have an objective or sufficiently reliable method for making case-specific conclusions. So it's fine for them to talk about different features. Maybe if they have enough data, they can talk about rarity, although you're skeptical. But to your mind, it's very clear that under Daubert, they should not be allowed to testify about the case-specific conclusion, whether or not there likely was copying in this case. But I'd like to ask you to think outside the box a little bit. So I think as a matter of current evidence orthodoxy, meaning Daubert, I agree with you that at least your position is consistent with a lot of the scholarly criticism about a bunch of other forensic science techniques and why forensic analysts should not be allowed to testify about the ultimate conclusion in whether or not there was a match, for example, between a tool and the tool mark that was left at a crime scene. But what I mean by asking you to think outside the box, is this the right way of thinking about expert evidence in this space? what I'm asking here is, okay, the experts might disagree on methodology. What they're doing might be highly subjective. But I think in your presentation, you yourself said, well, but they are using some considered expert judgment and they're using their experience in the area. So don't they offer useful evidence on this issue of copying? So if I were trying to figure out if one artist copied a work, frankly, I wouldn't want to figure this out myself because I don't really know anything about music. I'd probably ask you, or I'd ask my colleague Joe Fishman, or a musicologist. So why is that a problem?
Okay, so first of all, I'm not saying you can't ask a musicologist, right? There's lots of things I think the musicologist can provide to the jury within the rules. What I'm saying is that if you ask the musicologist, so did X copy from Y, you are now asking the musicologist to offer an opinion that doesn't have a sufficient basis for reliability in his field and is therefore likely to be the kind of personal assertion that the expert witness is making because, let's face it, one of the parties is paying the expert to have that opinion. So to see this, I would suggest, I understand your listeners may not want to do this, but I came to this conclusion when I started reading musicology itself, right? I went and read articles or books where musicologists were arguing about whether composer X copied from composer Y. And if two musicologists disagree, they just disagree. There's nothing in the field that says, well, 3 of A and 2 of B makes a normal case for copying. What they choose to consider, the weight they give it, there's no reference to musicological principles or orthodoxy to resolve that debate. And so I'm very concerned when you have parties who pay people to have an opinion. I'm very concerned that those opinions really don't rest on something reliable. They rest on the position of the litigant.
So I completely agree. This is a known, or it's a classic problem among experts. Since you're paying them, if you don't have any preset methodology, your worry is that they will slant everything in the direction of their client. Here's a different idea. So in previous work, I've argued that the way that we should use expert testimony is that we should ask the jury to figure out what most experts in the field might conclude on the issue. So it's a kind of idea of expert consensus. And I have a feeling, based on your previous answer, what you might think of this. But my question to you is, let's say we decide an individual expert should not testify about their own opinion, nor should the jury simply speculate about it because they don't really know very much about music and the things that go into determining whether there's enough circumstantial evidence of copying. What if instead we asked the jury to decide what most experts would conclude on the copying? And so then each of these expert witnesses would turn into almost a reporter saying, well, I think that the majority of the experts in this field would conclude X because, and then they would have to state reasons for that. Would that be acceptable to you?
That might be true if I was looking at DNA matching or something like that. I'm not very comfortable with this in musicology because that's a little bit like saying, do people think Beyonce or Taylor Swift is better? Personal taste, right? And so why would the law want to rely on that level of reliability? Let me say a couple of other things here. You mentioned juries speculating. Isn't there a difference with respect to how we expect trials to be conducted between the level of speculation we will permit in an expert witness and the level of speculation we will permit the jury to engage in when deliberating? I think the juries speculate in jury rooms all the time, right? They may go, maybe the reason we shouldn't believe him is, and who knows what the reason is, right? Or maybe the reason we shouldn't think that tire mark matches is, and then who knows what the jury thinks. And I think our system of litigation allows juries to go in many places where expert witnesses should not go. So that's why I'm not entirely frightened by the idea that sending these things to juries with some information from experts, but not suggestions about ultimate decision making from experts, is maybe reasonable within the existing framework of law. I certainly have ideas about how, you mentioned how we might use expert witnesses otherwise, but my ideas take us outside the boundaries of what law presently permits.
Final question for you. Is there anything next for you on this topic? I know you're primarily a copyright scholar, not an evidence person, but do you have additional evidentiary thoughts?
Yes. All right. I need to go back into copyright doctrine for a moment. One of the primary principles of copyright is that copyright protects the expression in a work, but not the ideas in a work. You're free to borrow whatever ideas you find in someone's novel as much as you would like. And of course, in any composition are what things that courts would call ideas and things that courts would call expressions, right? A 5-note motif might be an idea. A longer melody might be an expression. The reason copyright law maintains this distinction is a conviction that there are certain building blocks, certain small elements of every work that are borrowed freely by other creators and whose borrowing is necessary for the creative art to flourish, right? If all novelists could never borrow anything that they had seen in any other novel, novel writing would probably be relatively impoverished. Now, the determination of what is an idea and what is an expression is not empirical, right? It's not like, well, a zebra is a horse-shaped animal that is white with black stripes. That's not how we identify ideas. Ideas are really identified on the basis of policy decisions made by courts. If we allowed people to propertize this, then we would ruin the art of composition, right? Or again, if we allowed people to borrow the idea of boy meets girl or wizard goes to boarding school, books would be impoverished. These policy decisions could be illuminated by expert testimony. Right now, what judges do is they play armchair musicologists, right? They make assertions about the nature of creativity, which may or may not be accurate with respect to the art form they are writing about. And so I'm starting to think about ways in which we could get expert witnesses to inform or otherwise assist courts in making these policy determinations.
So I said that was the final question, but now I'm tempted to give you one more because this idea is so interesting. If you do that, are you not changing the improper appropriation piece of the copyright doctrine? And I'm not saying that this is necessarily bad as a normative matter, but are we not saying that what constitutes improper appropriation, what is too much, should really be determined by the musicologists or the experts and not the lay jury?
Okay, so first of all, I would agree with you that I'm going outside the law. But I think where I'm going outside the law is not so much on the distinction between copying and improper appropriation, but rather on the ability of courts to take expert testimony about matters of policy. Now, this is where I would defer to you as an evidence person. It's not my sense that this is normally done, that courts allow the parties to present expert witnesses on matters of policy, which are issues just for the court, because they are matters of policy, not questions of fact. So that's where I'm scratching my head.
Well, that I think is a very large topic for another day. Fred, thanks for talking to us about musicology experts and how they relate to copyright litigation. Great having you on the show.
It was a lot of fun. Thank you very much.
Frequent listeners of this podcast will undoubtedly draw deep parallels between Fred's discussion of musicologists and other conversations that we have had about more traditional forensic experts. Take handwriting, for example, which Fred does discuss in his article. What should handwriting experts be allowed to testify about? At the most basic level, they can point out similarities and dissimilarities in handwriting. More helpfully, if they have the data to back it up, the experts could testify about the rarity of those similarities or dissimilarities. And then finally, there's a temptation to have the handwriting experts reach a conclusion on authenticity. Is the signature genuine or is it a forgery? After all, juries don't look at signatures and handwriting all day long. So, what does the expert think? But the experts don't have all the answers. They don't necessarily have the hard data to back up their impressions or the standardized, reliable methods that we normally expect of science. And so critics worry that biased experts might not help the jury very much and are in fact more likely to mislead and distort. And so it is also with musicologists and musical features in a copyright case. The exact details between music and handwriting are, of course, different, but the basic conceptual problem remains the same. What do we want the experts to testify about, and what do we want to leave for the jury? And how much research do experts need to back them up before they are allowed to offer their opinions? These are all timeless questions in the expert evidence space. One other point. Practitioners know this implicitly, but what makes a good expert in court is often more about the expert's teaching ability than their credentials or even their substantive expertise. And I've often thought that this is especially true in the music space. The linchpin to the Ed Sheeran Marvin Gaye litigation was the question whether a particular chord progression was quote unquote copied or whether it was more like an idea, or in fact, an idea so common as to be banal. As a layperson, and not a very musical one at that, I don't really know anything about chord progressions or music theory. But here's where music experts can be highly effective if they teach creatively. Ed Sheeran, for example, gave a famous interview after the litigation discussing his testimony, in which he used the same chord progression from his litigated song, Thinking Out Loud, and showed how it could be used in other pop songs as well. In fact, probably the best demonstration of this issue of shared chord progressions is seen in the comedy band Axis of Awesome's piece, Ford Chord Songs. If you haven't seen the video on YouTube before, you should. It's brilliant. They take you on a journey through the history of pop music while playing the same chord sequence. In their case, they start with Journey's song Don't Stop Believin' and move all throughout the pop space, featuring songs including Lady Gaga's Poker Face. We in the evidence world focus intensely on knowledge and expertise. But these examples are a reminder that in the expert evidence world, presentation matters as much as knowledge. It doesn't matter how brilliant your expert is. If the jury doesn't learn from that expert, it's all for naught. And of course, it can't hurt to have Ed Sheeran pull out his guitar and play songs in open court. Now that, I think, is unfair. Support for Excited Utterance is generously provided by Vanderbilt Law School's Branstetter Litigation and Dispute Resolution Program, as well as the Texas A&M University School of Law. The associate producer is Alex Nunn, and the production editor is Anirudh Morella. Additional production assistance is provided by Lizzie Herrera, and background music is provided by Kirsten Castle-Greer, Felix Wong, and Alex Crew. I'm your host, Ed Chang, and I hope you'll join us again next time when we take on another new work in the world of evidence and proof.